The Supreme Court just dropped a 6-3 emergency ruling in Trump versus Casa Inc. that's going to affect millions of Americans starting as soon as next month. And here's what almost nobody is reporting yet. This decision doesn't just change one law or one policy, it fundamentally rewrites how legal protection works in this country. This isn't just a legal headline, it's a tectonic shift in how power is exercised in America. And right now, in state capitals and federal agencies from DC to California, the rules of the game have been rewritten overnight. Before we get into the details that are going to shock you, hit subscribe so you never miss breaking Supreme Court news that directly impacts your rights. Here's what actually happened late last night. The Supreme Court released a 6-3 emergency decision through its shadow docket, meaning there were no oral arguments, no months of deliberation, just a sudden ruling that changes everything. The case centered on a high-stakes executive order regarding birthright citizenship, but the court didn't just rule on citizenship. They used this case to settle a decades-long war over judicial power. And the core issue is this. The court just decided that federal judges can no longer issue what's called universal or nationwide injunctions when reviewing challenges to state and federal laws. Now that might sound like legal jargon that doesn't affect you, but stay with me because the implications are absolutely massive. For those who aren't legal scholars, here's the translation. For the past 25 years, when someone challenged a law they believed was unconstitutional, a single federal judge could issue an order blocking that law from being enforced anywhere in the country while the case moved through the courts. If a group sued over a new federal policy they didn't like, a single judge in a place like Hawaii or Texas could hit a global pause button. That one judge could stop the entire US government from enforcing that law across all 50 states, even if the lawsuit only involved 3 people. This happened in immigration cases, healthcare disputes, environmental regulations, gun laws, you name it. One judge in California could freeze a federal policy in all 50 states. One judge in Texas could block a regulation from taking effect nationwide. The Supreme Court just ended that practice. They just smashed that pause button into pieces. And according to court filings analyzed this morning, there are currently 68 active nationwide injunctions affecting everything from workplace safety rules to voting procedures to prescription drug access. Under this new framework, many of those protections could evaporate within 60 to 90 days as lower courts scramble to rewrite their orders. What makes this even more urgent is the timing. We're heading into an election year with major policy debates on immigration, healthcare, and civil rights, and this ruling just changed the rules of engagement for every single one of those fights. The majority opinion was penned by Justice Amy Coney Barrett, and it was surgical. She was joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Thomas. Their argument, the Judiciary Act of 1789, the very foundation of our court system, never gave judges the power to protect people who aren't even in their courtroom. Barrett wrote that for the past 2 decades, lower courts have been inventing power out of thin air. She argued that the role of a judge is to solve a specific dispute between specific people, not to act as a junior varsity Congress that can veto presidential orders for the entire nation. But here's the part that's going to generate the most backlash, and it's something the mainstream coverage is completely missing. The reasoning behind this decision goes way beyond what most legal experts predicted, and it's actually more radical than the ruling itself. Justice Gorsuch wrote a 28-page concurring opinion that reads like a history lesson, and in it, he presents evidence from 1789 through 1870 showing that American courts never once issued an injunction that protected people who weren't actually parties to the lawsuit. He cites 17 different cases from the founding era where federal judges explicitly said their power was limited to providing relief to the specific individuals standing in front of them, not to the general public. One case from 1834 involves a Virginia merchant who asked a judge to block a federal tariff from being enforced against anyone, not just himself. The judge refused, stating that judicial power extends only to the parties in the subject matter before the court. Nothing more. Justice Thomas went even further in his concurrence. He has been calling for this for years, arguing that nationwide injunctions are a modern malady that encourages forum shopping. That's the practice where advocacy groups hunt for a friendly judge in a specific district to kill a policy they don't like. He took this to its logical conclusion, arguing that Article 3 of the Constitution creates an inherent limitation on federal court power. The Constitution says courts can only decide cases and controversies, which by definition means actual disputes between actual people with actual injuries. It doesn't give judges the authority to issue broad policy declarations that affect millions of people who aren't even involved in the lawsuit. According to the majority, that era of forum shopping is officially over. Now here's where it gets interesting. The dissenting justices, led by Justice Sotomayor, tried to argue that nationwide injunctions have been essential tools for protecting civil rights since the 1960s. They cited landmark desegregation cases and voting rights cases where courts issued sweeping orders. Justices Sotomayor, Kagan, and Jackson argued that the court has effectively kneecapped the third branch of government. Justice Sotomayor's dissent was particularly pointed, warning that by stripping courts of the power to issue universal relief, the majority is giving the executive branch a green light to enforce unconstitutional policies for months or years while individual lawsuits slowly grind through the system. She highlighted a terrifying scenario. If a policy is plainly unlawful, why should it only be stopped for the person who has enough money to hire a lawyer? Why should everyone else in the country be forced to suffer under an illegal rule? But the majority basically said those landmark civil rights cases were wrongly decided on this specific procedural point, even if the underlying civil rights outcomes were correct. That's a stunning admission, because it suggests decades of civil rights litigation may have been built on constitutionally shaky ground. The dissent argues that this ruling creates a geographic lottery for justice, and as we're about to see, that's exactly what's happening. Within 48 hours of this ruling being published, the entire legal landscape shifted in ways most people haven't noticed yet. There are currently at least 47 active cases in federal courts where states and advocacy groups are seeking these exact kinds of blanket injunctions. From immigration sweeps in Los Angeles to environmental regulations in the Rust Belt, the legal safety net has been pulled back. Attorneys general from 18 different states filed emergency motions in federal courts, either trying to preserve existing injunctions or arguing that previously blocked laws should now take effect immediately. Texas filed motions in 4 separate cases involving immigration enforcement, arguing that injunctions that currently block deportation policies nationwide should be limited to only the specific plaintiffs, which would allow ICE to resume full enforcement everywhere else. They are citing this decision to push forward with immigration policies that were previously blocked. Florida submitted emergency briefs in 3 cases involving social media regulations and election procedures, making the exact same argument. They are using it to bypass federal regulations on social media. California and New York countered with their own emergency filings, trying to preserve nationwide injunctions that currently block various federal policies they oppose. But here's what's really happening behind the scenes. According to sources familiar with internal discussions, the Department of Justice held emergency strategy sessions with over 200 federal attorneys across 47 different cases to figure out how this changes their litigation approach. The White House counsel's office sent a confidential memo to all federal agencies warning them to prepare for laws they thought were blocked to suddenly start being enforced, potentially in a matter of weeks. The speed of the reaction tells you everything. Legal strategists view this as a massive win for the executive branch and a devastating blow to judicial resistance. And it's not just government lawyers who are panicking. Major advocacy organizations on both the left and the right are completely rewriting their litigation strategies. The ACLU has cases challenging immigration policies, surveillance programs, and criminal justice procedures, all of which relied on getting nationwide injunctions. The Alliance Defending Freedom has cases challenging LGBTQ protections, abortion access, and religious liberty issues with the same strategy. Both organizations just lost their most powerful weapon. What's even more significant is the economic response. Within 36 hours of the ruling, 3 major law firms sent client memos warning that civil rights litigation, environmental cases, and constitutional challenges could now cost 5 to 8 times more than they did last week, because instead of filing one lawsuit in one friendly court, plaintiffs might need to file in 15 or 20 different jurisdictions to get similar protection. This is a litigation strategy revolution, where only the wealthiest corporations can afford to defend their rights. But the question nobody's asking yet is this: if your constitutional rights can be protected in California but not in Texas, or vice versa, based purely on where someone happened to file a lawsuit, are we still one country under one constitution? The answer to that question determines what happens next with the policy areas that are about to explode. We are moving toward a boutique justice system where the law is a shield for the few and a sword against the many. Let's get specific about what this means for actual policies affecting real people starting in the next 30 to 90 days. Immigration enforcement is ground zero. Right now, there are 19 different nationwide injunctions, limiting various aspects of how ICE operates, covering everything from detention standards to asylum processing to deportation priorities to workplace raids. Under the new framework, those injunctions might only apply in the specific judicial districts where they were issued. Consider the birthright citizenship executive order at the heart of this case. Before this ruling, 3 different district courts in Washington, New Jersey, and California had blocked the order nationwide. They argued it was a blatant violation of the 14th Amendment, but because of this 6-3 shift, the Supreme Court has partially stayed those injunctions. The result? The executive order can now be enforced everywhere except against the specific plaintiffs in those cases. That means immigration enforcement could look completely different depending on which state you're in. The Department of Justice and the Department of Homeland Security are already moving to enforce policies that were previously frozen. In California, a federal judge had previously barred roving patrols from questioning people based on their appearance or language, a practice civil rights groups call racial profiling, but the Supreme Court just issued an emergency order in Noem vs. Perdomo that overturned that block. Now, ICE and Border Patrol have a green light to resume these patrols. ICE could potentially resume detention practices in Texas that are still blocked in California. Asylum rules could vary between the 9th Circuit and the 5th Circuit. Workplace enforcement could be aggressive in some regions and limited in others, all based on the geographic scope of various limited injunctions. In Los Angeles, you might be protected if you are a member of a specific organization that sued, but your neighbor, born under the exact same circumstances, could be targeted. This creates a life-and-death scenario for thousands of families who are now living in a state of legal limbo, unsure if the protections they relied on yesterday still exist today. Gun rights represent another immediate flashpoint. There are currently 8 nationwide preliminary injunctions blocking enforcement of firearm regulations in 6 different states, while those cases move through appeals. If those injunctions get narrowed to only protect the named plaintiffs, state officials could immediately start enforcing restrictions on everyone else. Your Second Amendment rights could literally change the moment you drive across a state border, not because the law changed, but because the injunction protecting you from that law only applies in certain places. Healthcare access is equally affected, and this is where it gets really personal for millions of people. There are 14 active cases involving nationwide injunctions related to abortion medication, gender-affirming care, contraceptive coverage, and religious exemptions to healthcare mandates. We are already seeing this play out in cases like Trump vs. Orr, which involves LGBTQ rights and gender designations on passports. The Supreme Court recently ruled in favor of the administration, allowing the State Department to refuse gender-neutral markers for anyone not part of a specific certified class of plaintiffs. Medication that's available through telehealth in states covered by certain injunctions might become inaccessible in states outside those jurisdictions. Healthcare providers could face prosecution in one state for services that are protected by injunctions in neighboring states. If the federal government decides to stop funding certain types of medical care, as they did in Scarametti, an injunction might protect families in Tennessee who sued, but leave families in 25 other states with the exact same healthcare needs completely exposed. Environmental regulations are similarly tangled. The EPA is currently operating under multiple nationwide injunctions blocking clean water rules, air quality standards, and climate-related regulations. If those injunctions become geographically limited, environmental protection could become a patchwork where federal standards apply in some regions but not others, creating a nightmare for companies trying to comply and communities trying to protect their health. Employment law is about to get incredibly complicated. There are nationwide injunctions affecting overtime rules, workplace safety standards, contractor classifications, and anti-discrimination protections. If those protections only apply in certain circuits, employers with operations in multiple states could face completely different federal requirements depending on location. Federal employees can be fired in mass Schedule F reclassifications because the courts can no longer issue a nationwide stay. So here's what you need to understand. Federal law isn't changing, but whether that federal law gets enforced against you depends on where you live and whether that location falls within the geographic scope of whatever limited injunctions might exist. We're potentially creating 50 different versions of federal law, all technically the same on paper, but enforced completely differently in practice. And that brings us to the issue that's going to cause the most chaos in the next 12 months. This ruling just created a potential constitutional disaster for election administration, and the timing could not be worse. We're heading into a presidential election cycle, and right now there are 11 nationwide injunctions affecting various aspects of how elections are conducted in 22 different states. These injunctions cover voter ID requirements, mail-in ballot procedures, early voting periods, voter registration deadlines, absentee ballot rules, and voter roll maintenance. Under the old system, one nationwide injunction could block a state law from being enforced anywhere in that state. Under the new framework from this Supreme Court ruling, that same injunction might only protect voters in the specific counties where the plaintiffs live. Think about what that means practically. The same state election law could be enforced in 75% of a state's counties while being blocked in the other 25%, based purely on where lawsuits were filed. We are already seeing the first signs of a disaster. In December 2025, the Supreme Court issued an emergency stay in Blanche versus Perlmutter, allowing Texas to use a contested congressional map that a lower court had found to be discriminatory. Under the old rules, if a court found a voting map or a mail-in ballot procedure to be unconstitutional, they could stop it statewide. Under the CASA framework, we could see a reality where a voting law is blocked in one county but enforced in the next. Election administrators would need to print different ballots, train poll workers on different rules, and set up different procedures for different parts of the same state, all while trying to maintain public confidence in election integrity. The National Association of Secretaries of State issued a statement calling this an operational nightmare. How do you conduct a fair election when the rules literally change depending on which county you're voting in, not because of different laws, but because of the geographic limits of different injunctions? And here's what makes this politically explosive. Both parties have used nationwide injunctions extensively to challenge election laws. Between 2020 and 2024, conservative groups obtained 9 nationwide injunctions blocking various election procedures they opposed, while progressive organizations secured 13 such injunctions during the same period. Both sides just lost that weapon simultaneously. The result could be the most legally chaotic election season in modern American history, with different rules in different places, constant emergency litigation, and no clear path to uniform national standards. While everyone's focused on the political implications, corporate America is quietly having a meltdown over this decision, and the economic consequences could be staggering. Companies that operate across multiple states are suddenly facing the prospect of navigating dozens of different regulatory environments where federal rules might be enforced in some locations but blocked by limited injunctions in others. While the human toll is staggering, corporate America is dealing with a different kind of life and death implication: the survival of the national marketplace. The U.S. Chamber of Commerce released an analysis estimating that compliance costs for multi-state businesses could increase by $53 billion annually if they need to maintain different operational standards in different jurisdictions. Banking and financial services are particularly affected. There are currently 4 nationwide injunctions blocking federal regulations on cryptocurrency exchanges, lending standards, overdraft fees, and consumer data protection. Imagine you are a multi-state bank or a pharmaceutical company. For decades, if the government issued a rule that was unconstitutional or illegal, you could get a single injunction that stopped that rule across all your offices. Now that is gone. You could be forced to follow one set of data privacy rules in the Ninth Circuit on the West Coast, while those same rules are blocked in the Fifth Circuit in Texas and the South. If those injunctions become geographically limited, banks might need to operate under different federal rules in different states. Technology companies face similar chaos around content moderation requirements, data privacy rules, and antitrust enforcement. A tech company could be required to follow certain federal regulations in states not covered by injunctions while being exempt from those same regulations in states where limited injunctions apply. Healthcare providers and insurance companies are staring at potential disaster around coverage mandates, prescription drug pricing, and telehealth regulations that could vary based on geography rather than being uniform nationwide. The pharmaceutical industry is especially concerned. There are 6 current injunctions blocking various FDA enforcement actions related to drug approvals, safety monitoring, and marketing restrictions. If those injunctions only protect companies in specific circuits, a pharmaceutical company could face federal enforcement in some states while being protected in others for the exact same conduct. Employment lawyers are already advising corporate clients to prepare for different workplace regulations, wage requirements, and discrimination standards depending on where each facility is located. A company with offices in 15 states might need to comply with 15 different versions of federal employment law based on which locations fall within the scope of various limited injunctions. The compliance costs alone are estimated to hit $47 billion annually. Major law firms are already telling their clients to prepare for litigation warfare. What's particularly frustrating for businesses is the uncertainty factor. Nobody knows which existing injunctions will survive under the new standard until lower courts revisit each case individually, which could take months or years. Companies are being forced to make compliance decisions worth millions of dollars without knowing what the legal landscape will look like 90 days from now. But there is a bigger story hiding in the background. This isn't just about injunctions, it's about who actually runs the country. What we are witnessing is more than just a change in legal procedure. It is a fundamental shift in how the Supreme Court asserts its authority. Legal scholars call it the shadow docket, the court's emergency docket, where high-stakes decisions are made without the traditional months of briefing, oral arguments, or lengthy signed opinions. In 2025 alone, the Supreme Court has ruled in favor of the administration in roughly 67% of substantive emergency applications. By issuing the ruling in Trump versus Casa Inc. through this expedited process, the court sent a message to the entire federal judiciary. The era of lower courts checking executive power is over. This represents a Supreme Court power play that micromanages the lower courts in ways that were unthinkable a decade ago. Justice Jackson, in a blistering dissent on the shadow docket, noted that the court is cavalierly picking winners and losers in cases that haven't even been fully litigated yet. The most explosive aspect of this shift is how the court is using emergency orders to effectively overrule long-standing law without actually saying so. In Trump versus Wilcox, the court used the shadow docket to allow the firing of independent agency officials, ignoring the landmark 1935 case, Humphrey's Executor, which protected those officials from political removal. Justice Kagan warned that this allows the president to overrule precedent by fiat. When the Supreme Court uses a one-page emergency order to tell a lower court judge they were wrong, it leaves other judges in a state of paralysis. They no longer have a roadmap of legal reasoning to follow. Instead, they are forced to guess at the Supreme Court's will. This creates a judicial chilling effect, where lower courts become hesitant to block even the most blatantly unconstitutional executive actions for fear of a swift, unexplained reversal from above. This reassertion of authority hits the hardest when it comes to civil rights. For over 60 years, broad injunctions were the primary tool used to enforce desegregation, disability access under the ADA, and voting rights. By insisting that relief must be limited to the named plaintiffs, the Supreme Court has made it nearly impossible to solve systemic discrimination. If a state passes a law that suppresses the vote of a minority group, a judge can now only protect the specific 10 people who sued. The other 100,000 people in that same community, they are left unprotected unless they file their own lawsuits. This turns the pursuit of justice into a war of attrition. Civil rights organizations like the NAACP and the American Immigration Council are sounding the alarm that this ruling could set progress back by decades, requiring thousands of individual court battles to achieve what one used to accomplish. Justice Jackson called this an existential threat to the rule of law, arguing that it creates zones where the executive branch can effectively opt out of the Constitution for anyone who hasn't already sued. This Supreme Court ruling fundamentally changes how federal power operates in America, and we're only beginning to see the consequences unfold. As we look toward the 2026 election and beyond, the millions impacted are not just a statistic, they are the American public. We are now living in a country where immigration agents can resume racial profiling practices in specific cities because the universal block was lifted, where federal employees can be fired in mass reclassifications because the courts can no longer issue a nationwide stay, where small businesses face a $47 billion regulatory nightmare of varying rules across state lines. The Supreme Court's 6-3 ruling in Casa Inc. hasn't just changed a rule, it has changed the very definition of what it means to have a right in America. If your right to free speech, to vote, or to equal protection only exists if you have the money to sue for it personally, then those aren't rights, they are privileges. Whether this represents a return to constitutional principles or a dangerous fragmentation of legal protection depends entirely on your perspective. But either way, the legal landscape just shifted beneath our feet in ways that will affect immigration, healthcare, elections, civil rights, and business operations for years to come. We are entering a new era of American law. Whether you see this as a necessary return to the Constitution's original intent or as a dangerous expansion of executive power, one thing is certain: the legal patchwork is here to stay. Is this the monumental victory for the separation of powers that the president claims, or is it an existential threat to the rule of law, as Justice Jackson warns? The answer will be written in the courtrooms of 2026. If you want to stay ahead of major Supreme Court developments like this, make sure you're subscribed, hit the like button, and drop a comment with your thoughts on how this ruling will impact you. Do you think one judge should have the power to stop a law for the whole country, or was the Supreme Court right to end nationwide injunctions? Don't forget to subscribe for our deep dive next week on the Department of Government Efficiency and how this ruling is clearing the way for a total overhaul of the federal workforce.